Okay, we'll get started. I'll call the meeting to order. If you could please stand for the pledge. I pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, welcome to the March 7, 2019 Town of Riverhead Planning Board meeting. First item on our agenda tonight is a discussion item for K Road, East Suffolk Development Court minor subdivision. Okay, good evening.
Good evening.
You could-
Amy DeVito with Woodhull Expediting, 332 Woodhull Avenue, Port Jefferson Station, New York, 11776. This
Thank
is
you.
my client, Peter Kaywood. I'm the owner of the property.
Okay.
All right, so what we have before us is a minor subdivision application which seeks to subdivide an existing 2.26 acre parcel and create two new buildable lots. The parcel is presently vacant. The planning department has reviewed a minor subdivision plan last dated June 2018. The 2.26 acre parcel is located on the northwest corner of the intersection of Middle Country Road and K Road in Calverton. Subject parcel has approximately 196 feet of frontage along Middle Country Road and approximately 161 feet of frontage along K Road. Subject parcel is located within the RB 80 zoning use district, which requires a minimum lot size of 80,000 square feet. Surrounding area is predominantly residential, with 6 residential lots located to the north of the subject parcel and a 2.31 acre flood control parcel located to the west. The proposed subdivision is a type 2 action pursuant to SECRA. Now, the lot is located within the Pine Barrens compatible growth area. Pursuant to town code, the maximum clearing limits, including areas previously disturbed within the CGA, is 53% of the total lot area, or 52,383 square feet. One of the things that needs to happen on the map is that the map needs to be revised to demonstrate the clearing limits which comply with the clearing restrictions of the town code as well as the Pine Barrens Act. And once these areas are defined, the planning board should also consider placing conservation easements on these areas. In a letter dated October 17th, 2018 from the Central Pine Barrens Joint Planning Commission, they asked for clarification on the zoning of the property when the Pine Barrens Act was adopted. They basically said if the project constitutes development, meaning more than 53% of the clearing limits, then it will need to conform to the standards for land use in Chapter 5 of the Central Pine Barrens Act. The proposed lot sizes are 49,418 square feet each, meaning they will require a variance from the Zoning Board of Appeals. Any setback, property setback variances or lot coverage setbacks should also be demonstrated through this application and sought at the time that they make the lot size variation request. The parcel is located within the Riverhead Water District, extension number 44, and there's a 12-inch water main located in Middle Country Road, which could serve the two new parcels. The subdivision map demonstrates that they're going to be proposing individual curb cuts for each newly created lot. Due to the clearing restrictions on the property and the fact that it's on a state highway, the applicant may wish to consider revising the map to show a common access. This would presumably help them reduce the clearing that would be required and help them stay within the 53% clearing limits. If the applicant and the board decides that a common driveway is appropriate, an access easement will need to be established over the common driveway and include a meet and bounds description. Any easement must be reviewed by council of the planning board prior to the applicant filing the easement. The application was referred to Suffolk County Planning Commission. In a letter dated October 12th, 2018, the Planning Commission just had a comment that the town should confirm that the subject parcel is not designated as open space as any part of previous subdivision. We reviewed a title report on the property. The town attorney reviewed that, and they did not find any previously recorded restrictions or prohibitions on the property, so that was okay. While they're preparing their development plan, If the total amount of area disturbed is greater than 1 acre, the applicant will need to prepare a stormwater pollution prevention plan and have that approved by the town engineer prior to the signature of the Mylar. Subject parcels located within groundwater management zone 3, which allows 300 gallons per day of sanitary flow per 40,000 square feet of land area. Based on these calculations, it appears that the subdivision would meet the health department standards.
If he's just applying for a subdivision right now, he's not gonna need a SWIP for that.
When you're, for secra, we have to analyze the whole thing, the whole project. One of the comments from the town engineer was if the disturbance of the proposed development would exceed an acre, they will need to prepare a SWIP.
And did they make an application to the zoning board of appeals yet, or?
Denial letter was drafted up and was sent out to the applicant this week. They will be getting that and they will be able to make the application at that point.
Not
You
received
understand?
yet.
Okay.
As with all subdivisions, it will require approval from the Suffolk County Department of Health Services. If approved, the subdivision map must be filed with Suffolk County Real Property Tax Service as well as with the county clerk. So really with this application, the biggest issue is the plan needing to be updated to reflect the clearing limits, meets and bounds description of those clearing limits, and then really something that's up for discussion is the common driveway. If the it's a recommendation from staff. I don't know if the planning board feels that it's appropriate or what's the applicant's desire, but that's something that needs to be hammered out.
About the common driveway?
Yeah, I mean, if you're opposed to it, if you're okay with it.
I mean, we understand, that it will lessen the disturbance of the property, but even with the two, singular driveways for each parcel, I don't think we're gonna come close to disturbing an acre on either of these. I mean, they're a full acre, and even with the 53% clearing limit, even if we kept half of the parcel heavily wooded and undisturbed, we're still nowhere near this particular area.
I mean, if that's something that you could just be demonstrated, you
Yeah,
know, if you
which I think we can.
create a clearing limit, show that, demonstrate that it complies with the clearing limits. I mean, again, just keep in mind, you know, the 1 acre SWIP, that can cause, you know, significant cost to the
Right.
applicant, so it may be something you'd wanna consider.
Okay, and more to the point, that would create a situation where we would have to pull these houses much closer together to have a common driveway accessible to both homes, or set them back quite a bit, making the driveway longer, in which case that might actually create more of a disturbance than just having the singular, driveways from the street. I don't believe, DOT will have a problem with the, curb cuts either, as far as that application would go.
Have you spoken to DOT yet?
Just briefly, one of the, permit employees over at DOT, and we just kinda had a quick conversation about it, and they didn't seem to think there would be any issues over here. No formal application has been made as of yet.
So Greg, at what point, will the clarification be needed, and how do you obtain it for the Pine Barrens Commission?
Once the applicant demonstrates on the plan, if they can establish clearing limits and demonstrate that it meets the 53% clearing, I would just refer the plan to the Pine Barrens Commission and receive comment from them. But I did speak with them on the phone, and I asked them, if they can demonstrate that they can comply with the clearing limits. It's basically, it doesn't require any approvals, but just for clarity's sake, I would refer them and just have something in writing.
Yeah, I had a conversation with Pine Barrens as well, and it was basically the same exact conversation, so. And I feel that we could very easily meet the 53% clearing limit.
Okay.
Do you have anything you wanna add, Peter?
No, I don't see, any reason why the design can't comply with all of the comments.
Right.
Yeah.
And what about the conservation easements that staff recommended?
Yeah, I actually didn't see a copy of the staff report, so that's news to me, but I don't think,
I mean, it would just
I
be,
don't think that would be a problem.
wherever the clearing limits are established, that we would just, establish a conservation easement saying that, no ground disturbance, no removal of trees, anything like that.
are you okay with that?
Kept in its natural state.
Of course, it serves a good purpose.
Okay.
Okay, so I guess you'll be back after zoning, right?
Yes. we
Back
will.
up to zoning, and we'll need to see, plans. I mean, if they wanna come up with one plan or multiple,
Yeah. The reason why we didn't update the plan for this meeting was because, I wanted to have a conversation with the board and staff about the singular driveways before we ordered the updates to show the clearing limits.
I'm not opposed to having 2 curb cuts there.
Okay,
think it makes more sense if you're trying to preserve more space. I mean, to have a huge driveway and then tee it off, I think it kind of defeats the purpose or the goal.
Yeah. I agree.
Good fences make good
If you
neighbors.
made the lot lines perpendicular to 25A, then it would work, but you've got it on an angle.
Yeah, it would, but
That would be
even with that, I still feel, cause then we have to maintain a certain width for cars to come in, pass each other if they're coming out, it's still gonna create the same disturbance, really, when it comes down to it. Say again?
2 15-footers,
Curb cuts?
adjacent to each other.
Okay.
That's how you would do it.
Right.
Yes, then it would be practical to make the land division line perpendicular, exactly as you said. Yes, because it doesn't work very well this way.
No.
But that could be part
That's
of the developing the design, sure.
Board have any other questions?
I agree with that too.
I think that's the one, sure, I said. So, this is yours. Well, thank you very much, gentlemen. We appreciate the, input. And as soon as we receive the zoning book,
What is the board's desire on the comment?
Yeah, they're not gonna
they agree, they agree that we can have two separate permits.
Okay.
Okay, so our next step is gonna go to the zoning board of appeals.
With the new design?
Yeah.
Yes, with a new design.
Go on, declare on it, just so they can see it, and then, thank you again.
Thank you.
Thank you.
Okay, next item on the agenda is Hilton Garden Inn and Marriott Residence Inn. Construct a signalized intersection on Old Country Road.
Good evening, everybody. Mr. Browning couldn't be here because of some extenuating circumstances, so it's just me.
Okay?
I just wanted to kind of go over the resolution and refresh the board on the application because it's been a while. This is for a access driveway for the Hilton Garden Inn and Marriott Residence Inn. It's to the west of the existing driveway. The board recalls we did an administrative site plan approval for an amendment to the plans for the Marriott, and this access was supposed to be part of that. But at the time, we hadn't gotten formal comments from DPW, and the plans really didn't supply sufficient detail on the access. So that resolution did require a new amended application for the access, which was supposed to show more detail. Subsequently, the Marriott was actually given a certificate of occupancy, so this isn't an amendment, it's a regular site plan. So basically, a portion of the curbed island at the center of Old Country Road will be removed, and there'll be a dedicated eastbound left turn lane and a traffic signal. I just want to remind the board, the previous development required the redemption of 36.23 agricultural preservation credits for the Marriott Residence Inn. And this is a voluntary additional access that the applicant had requested. It's nothing that the town required. So there was a traffic impact assessment that indicated there wouldn't be any adverse traffic capacity impacts. There was a traffic signal warrant analysis which indicated there was a need for a traffic signal. And basically that the proposed signalized entrance would improve the safety of motorists entering the hotels, as well as minimizing the number of illegal U-turns taking place. Suffolk County Department of Works basically had their regular comment that a permit would be required. They also said that all sidewalks, driveways, and handicapped ramps must be ADA compliant. No DOT permit was required. They just wanted to make sure that their easement along the front of the property wasn't impacted. other than, they're cutting through it, it's not changing their easement. Although DOT did recommend that the left turn lane going in be fully protected by an arrow. Suffolk County DPW did not feel that was needed, but they would take a look at it once the signal was installed. We did have a public hearing back in July. Basically, we had discussed that they would need some varying of the development standards for reduction in parking below what was required, and also they'll need some relief for lighting. That's 4,000 Kelvin, when now it's required to be 3,000 Kelvin.
Right, why do they need the 4,000?
Well, they are coming into compliance for the vast amount of the lighting on the premises. It's only where they recently installed lighting over by the Marriott that they're requesting that the board vary it. So everything's gonna be 16.
What's their reasoning though, I don't understand.
I'm guessing it's because of cost, and they just installed it.
Oh, it's already installed? It says here, proposed.
Oh, I'm sorry, let me see.
No, it says,
For existing LED luminaires. The applicant seeks approval for existing LED luminaires. Page 4, second paragraph from the bottom. Unless I said that elsewhere. I don't believe so. So they were installed fairly recently at the Marriott before the code was changed.
Okay, I was reading the next page where it says proposed lighting.
Oh, sorry.
Any proposed lighting should be 3,000. That's just my opinion. That's what the code states.
The planning board finds that varying the existing 4,000 Kelvin lighting is acceptable.
Proposed, it says.
Okay, the existing 4,000, I'll take out the proposed. We can amend it to take that out. The board has allowed, let's say, higher poles and things like that where credits were used. So this is just to allow for existing lighting that's,
Okay, are
the
they all
Kelvin
dark
ratings.
sky compliant at least?
yes, they're bringing everything into dark skies compliant. They're putting in LEDs and things of that nature. I did want to mention, and Dick Ehlers may want to jump in at some point, there was a code section in the TDR code that allowed the planning board or the town board to vary development standards if TDRs were used, and somehow there was a mistake where when the town had to readopt the TDR code because of a legal issue, somehow the amendments to the TDR code were struck out. So although that's the case, Mr. Ehlers felt, even though it was inadvertently removed, the orderly interpretation of the TDR code by the planning board permits interpretations necessary for site-specific application of TDRs.
it was struck out of where, Karen?
It was struck out of the TDR code. There's,
I'm sorry.
oh, go ahead.
You recall there was litigation around the time of the Aldi's approval, and we wrestled with what to do with Aldi's in that breach of time. When they went to readopt the original TDR code, the first draft of that readoption listed the amendments to it. It was then realized that they didn't need to readopt the amendments because they weren't stricken by the court decision. Unfortunately, the portion that represented the amendments was overstriped with a center line, which the code publisher people interpreted to be an affirmative desire to remove those from the code when that wasn't the intention. It was to remove that verbiage from that adoption. So the town attorney's office is working, I saw today a draft of a new amendment to put the overstruck portions back in. Fast forward to my thinking on this tonight is whenever you're applying TDRs to a site, there's a natural necessity to vary the things that are related to what the TDR lets you do. In other words, we've wrestled with heights of buildings with more floor area. If the building has to go up to accommodate the floor area, you wouldn't get a TDR for the height and a TDR for the floor area. You'd say, practically, I have to do, the building has to go up to, if I'm going to allow it, the building has to go up. So I believe the board, as the body empowered by the town board to interpret the TDR ordinance, has the inherent authority to do what you're doing this evening. To utilizing a TDR facility, it requires you to make amendments. That's natural to do. So it's a long way of saying it seems to be okay.
Thank you.
So if the board is in agreement, you would be varying the Kelvin on some of the existing lighting, and then the reduction in parking stalls from the required 253 down to 242. Only 6 are going to be removed for the access. 4 were required to be striped as no parking in front of fire hydrants after the last site plan was approved, and 1 was an error due to a problem with the survey. So, so it was determined to be a type 2 action with no further environmental review. Basically, some of just the regular boilerplate conditions, including that no work shall commence within the right-of-way until a highway work permit is obtained. And then as far as signing the Mylar, there were some revisions needed to the Mylar, which were fairly minor. Adding no parking signage for handicapped access aisles, adding some parking subtotals, correcting some discrepancies between lighting details and the lighting schedule, removing some old extraneous asterisks from the zoning schedule, and just adding something about that 36.23 development rights were previously conveyed. We did talk about future cross access to the property to the west, that triangular property that really needs to have cross access to be developed. So there's a condition about that. Also that we need a fully executed traffic signal maintenance agreement between the town and Suffolk County Department of Public Works. They said that would be a requirement, so I don't think we want to go forward with them doing the site improvements without that. And that's basically it. Oh, one more thing. I did want to amend the resolution, number 7A2 on page 6. I wanted them to include, the site plan is made up of plans by the Eshwar Kasuri, the engineer on the project, and then they have plans done by the L.K. McLean Associates, which is more for the roadway improvements. And I just wanted them to include page 15, which I have listed here, which has the sidewalk and ramp details. But looking through the plans before the meeting, I saw that they really should include page 26, which is the pavement marking and signage plan, which really shows the turning lane very well with all the markings, the arrow markings, so.
That's the traffic report? That's in the traffic report?
No, it's in the, like I said, there's two sets of plans. One is more of the site plans, and one is the roadway plan. So rather than have them include, 30 pages of plans, I had them include some of the engineering plans as part of the site plan.
They're stamped individually, separate from?
Yes.
Okay.
Yes, and I'm having them put the planning board certification box on certain selected plans. We don't need all the engineering information as part of our site plan, but I thought it would be good to include a couple of those pages in addition to the ones we already have that really show the turning lane.
Did any of the architects or licensed people involved determine whether this is gonna increase safety, or is it just a matter of convenience for the customers?
No, the traffic assessment did say it was a, I did believe I read that, providing an exclusive eastbound left turn lane will improve the safety of motorists entering the hotels, as well as minimizing the number of illegal U-turns currently taking place, which has the potential of reducing accidents that could occur in the future. So,
Very.
is there any questions that anyone has?
Now we have a resolution for administrative approval tonight, right?
Right, with that amendment to add those couple of pages.
And Ed's.
I have two quick questions. The addition of the generator, noise abatement, any problems with that? And the-
No, that was just iterating the previous approval. It's already in.
That's
You're talking
already
about
in?
the first
Alright.
paragraph?
Okay, yeah, all right, and the other thing, the other question I had was about the relocation of the refrigeration unit. Now, it's
That was the previous site plan. I was just adding that in there, so you would know that
It's already done?
it's already
Basically?
done. That's
Okay.
all done. Thank you.
Okay, thank you.
Karen.
Okay, next item on the agenda, discussion item for S-Power, discussion of a supplemental environmental impact. I don't think it's necessary, really. I think we prepared it, right? We worked on it ourselves. The applicant
Yes.
chose not to
This is,
participate in it, so it's really between our consultant and the board. Correct?
Yes, I believe that's correct. The applicant was requested through a positive deck that was issued in October, requested to prepare a supplemental EIS. In lieu of that preparation, the sponsor submitted through its agents December 2018 consistency analysis to justify their position that a supplement was not required. But as lead agency, the planning board is responsible for the accuracy and completeness under SECR of the EIS, and the board elected to prepare its own supplemental EIS.
Okay. If the applicant has any comments, feel free during the public comment session, you could address the board.
So this evening's resolution is really for the adoption of the supplemental, so that it can be available to the public for comment and distributed to the involved agencies, with copies placed in the clerk's office, the planning department, and the Riverhead Public Library. This evening I can go through a litany of how we got here, or I think the board is probably fully aware of that, and in conservation of time, I really would like to leave it up to you to provide any answers to questions that you have on the supplement, or the process and procedures that we have before us before we complete SECR.
If you could, Jeff, maybe go to the summary.
Sure.
Just kind of brief the board on how you got to where, you know, this document is and what was covered in it.
Okay. So as I get toward the summary, it might be worth mentioning that there was at least one question raised during the draft EIS that the board felt was inadequately addressed, and that was with respect to any other proposed commercial solar facilities within Riverhead. Although the applicant responded that it had contacted the town for that information, it was clear that there was another application near pending, and it was after the finding statement that papers were actually filed with the PSC on what is called Riverhead Solar 2. Under SECR, we felt that that question was not adequately answered, but it also created a concern for segmentation. There's a SECR test for segmentation. There's 8 different questions that could be asked to determine whether segmentation has occurred, and during my analysis I found that 7 out of the 8 and possibly all 8 answered yes under the segmentation test. So to make sure that the secret record was corrected, I also identified that in a review, and this will clean all of that up for the record.
So Jeff, when was that Solar 2 project filed for in relation to when this board accepted the original EIS for S-Power 1?
Well, we did the finding statement on October the 19th of 2017, and the letter which was filed with PSC in New York for Riverhead Solar 2, which was one of the first steps in seeking a certificate of environmental compatibility for the 36 megawatt commercial facility, was October 20th, 2017, so the day after that.
Okay, thank you.
Was there a particular part of the summary? In the conclusion section?
Yes.
Okay. So, I listed out in the conclusions some of the more important dates in order to create a timeline as to when proposals were requested by LIPA in response to creating renewable energy facilities in order to meet their expected requirements and demands, and try to follow through to give the board some sort of a timeline as to how these events occurred, and when this application came forward, and during certain overlap periods during your secret review, and where their application to PSC was with the state. Now, the 36 megawatt facility is reviewed under the Article 10 procedures because it exceeds the 25 megawatt threshold. However, going back to the segmentation issue, SECRET doesn't distinguish to which agency you file. If it meets any of the thresholds for segmentation, irrespective of who is doing the review, and this board was lead agency, it falls under the segmentation category. So there were similar aspects of Riverhead Solar 1 and Solar 2. Certainly Riverhead Solar 2 was not speculative. Under SECRET, if it's sort of a pie-in-the-sky idea, maybe would never be developed, certainly that wouldn't qualify. Now, the applicant did provide a very generic overview of where other solar facilities could be constructed. I think there was a total of just under 5,000 acres that could potentially go solar within our permitted districts. All of those districts require a special permit, but the special permit also acts as a valve in order to control the development of any particular type of specially permitted use. But they did not specifically identify the second project. So, through the summary, I identified where they met the thresholds for segmentation. And I also used not only the SECRET record, but the information that was filed with the PSC in the form of the preliminary scoping statement, as well as the applicant's consistency analysis, in order to identify any conflicts between the secret record that we had and the statements that were offered by the sponsor. And then in the summary, I also provided a list of actions. I think that we've, through the supplemental process, we've certainly addressed the segmentation and the question as to whether or not there are additional facilities planned within Riverhead. And then I tried to identify some additional agencies that should be included as participants in the review process. During the Riverhead Solar 2 preliminary scoping statement, comments are offered to PSC in response to the review of it, because it is preliminary. And there were several comments offered by certain agencies that specifically questioned the lead agency's EIS under the Riverhead Solar 1 project, and whether or not Riverhead Solar 2 was identified, or how the two were going to impact the environment. So those comments came from the Central Pine Barrens Commission, New York State Department of Agriculture and Markets, and New York State DEC's Albany office. So I would encourage the planning department to make sure they're included in the circulation list, so they know that the lead agency saw those comments and responded to those comments, even though it was for a separate project. Now, the planning board and the town certainly have opportunities to participate in the Article 10 process, and I'm sure you would be encouraged to do so, because you have a lot of institutional knowledge really through the review of this application.
So how might we be involved to feel comfortable with how the power, or S-Power 2, is going to be regulated crossing Edwards Avenue?
I think that's yet to be defined. Now, the covenants that were placed on Riverhead Solar 1 clearly restricts the use of both the easement and the Gentile line to solely Riverhead Solar 1. I believe Riverhead Solar 2 provided this board a design, a sketch that showed an alternate location for crossing Edwards Avenue for the 36 megawatt facility, but I have not found in the record with PSC that has been affirmative. There were conflicting comments. There were comments that were offered in the preliminary scoping statement of September 2018 that claimed that they would use this common easement, or as they stated, be co-located within the existing and approved Gentile line. So there's not a final design, it's not a completed decision for Riverhead Solar 2, but they offered a second alternative, I suspect. The other question that was raised is the cumulative impact and growth-inducing impact issues. I believe that we looked at the Gentile line originally as a potential for others to tie into that easement and expand commercial solar facilities in this region. But you can't ignore that the substation is really the key here. That if there is a LIPA PSE&G substation and it is cost effective to make access and there's land available, that is really the magnet that will attract this type of development.
So as far as the capacity of that substation, do you know where they are with total capacity compared to what S-Power 1 and what's proposed for S-Power 2?
I do not. I believe in the S-Power 2 application, there was some recommendations, I think, that would be upgraded, but I'm not keen on whether that's factual. But I would imagine it could be upgraded.
Question for Dick Ehlers, would that expansion of that substation be subject to town permitting and the environmental process, or are they exempt?
Go right ahead.
That question, I did ask that question of Bob Kuzakevich, and he was reaching out and had that conversation with the town attorney from East Hampton, because they've had previous court experience, so to speak, regarding PSEG and permitting processes in their town. And I don't know whether or not there was a definitive answer from that research, but I know that he was researching it.
Okay.
You do get involved in the interplay between the state process to permit what they're asking for in solar two and the town's ability to impact that state process. So I think it's probably cloudier than just a straight if PSG wanted to expand that facility for their own upgrade analysis, as opposed to being driven by a particular application that may cloud that judgment. Might be why we're not able to give a definitive answer at this point.
We would be very interested in legal advice on that,
Okay,
or a legal opinion, I should say.
all right.
So to continue, I also, in the summary, made some, call them recommendations for future thought. There is currently, or there was currently, a proposal offered by the governor to provide 50% of New York State's energy through renewable resources. And a recent announcement is that that number is moved up to 70% by 2030. I view that together with the location of the substation or other substations, available land masses, et cetera, and the sheer size of some of these facilities to meet those anticipated renewable demands as a real challenge for Riverhead. So, and maybe a development pressure that we've not experienced in some time. While we've done, I think, a good job of looking at the code and revising it, I know the town board held a recent public hearing on another amendment to the code that would restrict vegetative clearing on sites for solar, to not allow clearing for vegetation above 3-inch caliber in order to control deforestation. But there's still a good deal of land available, so I made some recommendations to think about limiting through the code the size of facilities to below the 25 megawatt threshold. Even if these are presented to you in a phased approach, that would allow more local control. Right now, there's a lot of discussion going on between Article 10 and SEQRA, because under SEQRA, it's left up to local review boards, and under Article 10, it moves up to the state level with less participation and less control by local municipalities. And although this hasn't all been sorted out, one of the issues that people are wrestling with is that Article 10 allows a sponsor to petition for their renewable facilities under Article 10 whenever there is a burdensome local code, and no one's really defined what burdensome means. But it seems to lean more in favor of the sponsors and less for a local municipal control. But if you limited the size to a facility below the Article 10 threshold, you would be able to have better control over your land use. Now, these may seem radical, and they're just presented as parts of my comments in order to deal with this. However, the next step in this process will be to prepare a finding statement. And I'd ask you to take a hard look at some of those recommendations and determine whether or not some would be appropriate to build into a finding statement, and at least begin to circle the wagons for this board to not go through the process that we've just experienced with these applications. And if you have any specific questions.
What would be the next step after this? Does it have to be posted on the environmental bulletin?
Yes, it has to be announced through ENB. It needs to go onto the website. It needs to be available to the public, and there is a comment period. Actually, we have not received a lot of comments on the original Riverhead Solar 1 application, except for those that were generated, by staff and the board. So I don't think that this is classified as a major controversial project at that point. And that's always something that you want to weigh when determining the comment period. But it is a supplemental EIS, and it is, part of the secret process. And when you read how secret wants you to address comment periods, it's not really as specific for supplementals, because it just simply says all sort of procedures of this part shall be followed. So my approach was to follow it at the final EIS stage in order to correct the record, which is where I believe it was flawed. It wasn't flawed in the draft. And rather than go to the draft and start all over, we started at the final stage. But I leave the comment period up to the board.
Supplemental impact statement is complete.
Yes.
Will the pages that have the lead agency action, are they included in the supplemental?
No, I provided lead agency actions to Jefferson, but I can reiterate that form so that what the next steps would be to, if you adopt this evening, to have the planning board, make it publicly available, and then pick a time when you want to have the finding statement adopted. I've started its preparation. I'm about 75% complete, so whenever you're ready for it, I'll present it as a draft.
Sounds good.
Okay, thank you, Jeff.
Sure.
Thank you for the time this morning. Yeah, thank you for the time
Oh,
this morning.
my pleasure. Thank you.
Okay, before we get to the resolutions, is there any public comment on the resolutions?
Good evening, Chairman, members of the board. My name is Philip Butler. I'm with Farrell Fritz. I don't really have any comments. I just want to say, having had a brief opportunity to review the SEIS and hearing Mr. Seaman, sorry. His comments, it seems like the two issues that were of most concern to this board were the cumulative impacts that were raised by the Riverhead 2 project, as well as the potential segmentation issue, both of which, based on this SEIS, are now addressed, I believe, to Mr. Seaman's satisfaction. So just if the board would allow us to proceed with this process at this point, I think part of our battle was just understanding the process that we were going through, from here to getting to a amended finding statement. So now I believe we understand that process, and we're just looking forward to moving on with this. So thank you very much for the board, to the board.
Okay, thank you. Any other public comments? Okay, resolutions.
Make a motion to move resolution number 16, the Hilton Garden Inn Marriott Residence Inn.
I'll second.
Administrative site plan approval, so moved.
Second.
As amended.
As amended.
As amended.
Okay, motion made and seconded to approve resolution 16 for Hilton Garden Inn, for administrative site plan approval. All in favor?
Aye.
Opposed? Resolution is approved.
I'd like to move resolution 2019-17, which deems a supplemental environmental impact statement for the site plan subdivision and special permit of S Power complete.
Second the motion?
Okay, motion made and seconded to approve resolution 17 for S Power supplemental environmental impact statement. All in favor?
Aye.
Opposed? I'm opposed to it. Only, Jeff, you did an outstanding job with that, and I thank you for your hard work, but this applicant was not forthcoming with us. They didn't provide information that we directly asked for, so I really can't support this going forward, but you did a great job, and just wanted to thank you by vote no. However, the resolution passes 4-1. Okay, any comments from the public on any other matter in front of the planning board? Any other comments? Okay, meeting minutes of February 21st.
So moved.
Okay, motion made and seconded to approve the minutes of February 21st. All in favor?
Aye.
Aye. Opposed? Minutes are approved. Okay, next meeting is March 21st at 3 PM. Motion to adjourn.
Second.
All in favor?
Aye.
Okay, thank you.